everybody. Hey, Patrick. How are you?
Hi, Sylvia. Good to see you again.
Good to see you too. I'm so glad that you came back to visit us again. How's things going?
Oh, beautiful and sunny Florida as always. Today we have rain, so not too sunny.
Oh, so I'm not jealous today then. I'm not jealous
Okay.
of you guys. Hey, chat. How's everybody in the chat? Well, welcome again, Patrick. I thank you so much for your time and being here. Um, there are a lot of things has happened since the last time we spoke,
I
as
see.
in regards to Robert Sylvester Kelly's case. As you already know, he was convicted of all the charges of the RICO as well as the Mann Act. Um, what happens next? Now, he has the Illinois federal case coming up, which the court date has been set for August the 2nd.
Right,
Um,
August. I see August 1st. I'm looking at the docket right
August
now.
1st. I'm
August
sorry, you're
1st,
right.
2022.
Hmm.
That's a lot of time.
Yeah, and also his sentencing is all the way in May the 4th, I think. That's what I.
Right, right. It's not uncommon for sentencing to be put off that long, especially in a case like this.
Okay, and you know that he just recently hired Miss Jennifer Bongine. Are you familiar with her?
I am. I know that name. I don't think we've crossed paths, but I definitely have checked out cases that she's been involved in before.
Okay. Okay. Well, there's a lot to start from, so I don't know where we want to start from because I did send you some stuff. I did check with them. I did make that phone call, like you said, and they said that they redacted that
Okay.
information. Yeah. So
Okay.
you were correct when you told me that it's a possibility that they just don't show it to the public,
Right.
and they did say that they don't show it to the public.
Right. So what we're talking about is, if just for the benefit of the audience, there is
Hmm.
the indictment, like in federal court, like it is in most states, has to be returned in open court by the jury foreperson, signed by the jury foreperson, and presented to the judge that presides over the grand jury term, which is
Hmm.
sort of like the period of time that the grand jury sits. They're
Hmm.
chosen as jurors to sit for a specific term or a specific period of time, or
Hmm.
sometimes if it's a special grand jury investigating a special case, they sit for that particular case and that case only. Now, the federal rules of criminal procedure require all indictments to be signed by the grand jury foreperson and to be returned in open court. The problem is that, or I don't say the problem, but the issue is that a lot of times the prosecutor will just present the defense lawyer with a piece of paper that
Hmm.
looks like an indictment and doesn't have a signature at the bottom. And the question is whether the foreperson really did sign it or not. The problem is we'll never know.
Oh.
And the reason is that the law provides that jurors' names are withheld, and especially with grand juries, there's special laws apply to the grand jury that protect grand jury secrecy.
Hmm.
So generally speaking, you're not going to get the name of any of the grand jurors, and that's why they take a magic marker and they redact out at the bottom. Well, now you do it by computer. But in the olden days, when I was young, they would take a magic marker, a sharpie, and redact out the signature of the grand jury or the grand juror that signed the indictment, so you didn't know their name and they couldn't be doxxed, they couldn't be
Okay.
exposed.
Okay.
That's the same reason why the proceedings in court may or may not be recorded, meaning audio recorded or taken down by a court stenographer when the
Hmm.
grand jurors come back into the courtroom and the foreperson comes and says, "Hey, judge, this is the indictment. I'm giving this to you." It may or may not be recorded. So grand juries are always shrouded in secrecy. I'm very much against that. I don't think that any government should operate in secrecy. I think the process that we have here in Florida State Court,
Hmm.
where they don't use a grand jury, they can, but they really don't.
Hmm.
Um, they just, the prosecutor wants to charge you, they file a charge, and
Hmm.
everybody's out in the open, and
Hmm.
everybody knows who signed it because the signature is right there. Everybody
Hmm.
knows who filed it. I'd much rather do that than deal with the secrecy of a grand jury in a one-sided presentation that's only the prosecutor gets to present evidence, and then group of people are supposed to decide whether there's enough information there to basically destroy somebody's life on a
Mm.
one-sided presentation. I don't like that.
Yeah, it's not, it doesn't seem fair. Speaking of secrecy, what do you think about that whole thing where Robert's case was behind closed door, where you really couldn't, um the public was not really had didn't have access to his case. They didn't even have like call-ins where you could listen to the actual trial on the phone or anything like that. So what do you think about how that was handled?
Um, so we have right now going on two major cases of public concern, right? One in
Mhm.
Wisconsin and one in Georgia,
Mhm.
where those are both in state court, and both in state courts that allow courts to broadcast live these court proceedings, and you can watch them. And I've been watching parts of both of them
Mhm.
on YouTube all day. Federal court does not allow that. New York State court does not allow that. And I'm sure there's other courts in other states in the country that also don't allow that. Um, I think in an era of technology where, and especially in a post-COVID and COVID environment, there is absolutely no justification for keeping people in the dark about what's going on. Yes, it's a public courtroom. No jurors should not be shown to the public.
Mhm.
But when it comes to the witness testifying, the lawyer, the defendants, the judge, the major players in the case, except for the jury, public has a right to know. We have the technology available. I can't be in Kenosha, Wisconsin. I can't be in Georgia. I have to be here taking care of my personal life. But I
Mhm.
would like to know what's going on there, and it shouldn't be limited to only the people that have the ability to travel there. What if, I'm able-bodied, but what if I was handicapped? What if I had some sort of disability that didn't allow me to leave
Mhm.
the house and go to a courtroom to watch what's going on? We as a society have an interest in what's going on in our community. We should be watching these court proceedings. We have the right to watch these court proceedings. And now that we have the technology, there's no reason why we shouldn't be able to stream these things and watch what's going on. Federal courts really should get behind, or should get in front of technology, get out from behind the times and get with the program, in my opinion.
Yeah, but even with the access, they only allowed 8 outside people to be in there in the first place,
That's
as far
ridiculous.
as the outside. Now, do you think, like, as people, there could be like a lawsuit with the against the federal government for not allowing us, as because that's our right, to be able to be in the courtroom
Well, certainly,
with.
yeah, and especially for media. If you have media credentials, there's a
Mhm.
First Amendment right for the media to be present in these kinds of things. Forget about the constitutional right that every citizen has,
Mhm.
which is to have the right to an open and public trial. We're talking about a defendant here who, has a right to an open and public trial. You don't get that when you're limiting the number of people that can observe the proceedings, because we know from experience that people may act differently and they may be a little bit more honest when there are more eyes on them. That is the
Mhm.
whole, basis for putting that into the Constitution 200 some odd years ago, is we don't want government to operate shrouded in secrecy, because that's when people, get screwed.
Mhm.
The more eyes that are upon you, the better.
Yeah.
And there's no reason why anybody should be limited. But media certainly has, and they have in the past, filed lawsuits in order to gain access to certain court proceedings, to be to have their exercise their right to report to the public. I don't know if you saw the headlines today that MSNBC has now been barred from the courtroom in Kenosha
Hmm.
because of an incident that occurred. Basically, what and it always takes one person to screw up the party for everybody, right?
Mhm.
Um, the jurors in that case were videotaped by some individual about a week or so ago, and obviously it made the jurors nervous and it made the court nervous, because this individual, if you're videotaping jurors outside the courthouse, gathering in a location, and entering through a private juror door,
Mhm.
obviously it sounds like they want to expose who they are. They want to dox them.
Mhm.
So what the judge did was take some steps to ensure that the jurors felt a little bit more comfortable, and they're having them assemble in an offsite location, and they're being bussed in with a bus that has coverings over the windows so that people can't watch and see who's on that bus. And I guess they're entering the courthouse through some sort of entrance where the public's not going to be allowed. That's to protect the jurors' privacy.
Mhm.
Some character today was following the bus, went through a red light in
Wow.
order to keep up with it. The police pulled them over, and they said that they were a reporter working for MSNBC, and
Mhm.
that their boss had told them to keep following the bus.
Mhm.
And that got back to the judge, and now the judge says, "Okay, MSNBC is out of the courtroom." Well, I anticipate a lawsuit being filed by MSNBC saying you can't bar access. That's our First Amendment right. We have a right to be in this public courtroom. We have a right to report on these proceedings. I have a feeling that that lawsuit's going to be filed
Wow.
probably tonight, if not tomorrow.
You keep mentioning doxing. What exactly is doxing?
Doxing is when somebody posts another person's private information, their image, their home address, phone number on the internet, like on Twitter or something, in order to, basically what it's doing is you're inviting the loonies to come out and start calling you or stop by your house or make threats or whatever. That's what doxing is, and that's what we don't want to happen with jurors, because jurors need to be in a situation. They already have enough pressure on them as it is.
Mhm.
We don't need them worrying about consequences when they go, after the case is over, going back to their community. We want them to concentrate only on what's in that courtroom, not having to worry about all these extraneous considerations. If I go home, will my family think of me? Am I going to have people coming by my house, threatening me, yelling at me in the street, saying things about me because I served on a jury for, whatever whatever the result is. That on either side there's always going to be loonies, and there's always more than two sides, so there's loonies on every side. You don't want these people being exposed, because that prevents people from doing their civic duty. And then
Okay.
what happens if we don't get jurors? What if
Yeah.
nobody wants to serve? Well, I know exactly what happens as a trial lawyer, having done 50 jury trials. You get bad jurors on your case, and people end up losing their rights when you have bad jurors on the case. You want good jurors. You want people that feel comfortable doing their
Mhm.
civic duty.
So it's basically if okay, for example, as a blogger, say someone posts my address and makes threat, is that considered doxing?
Oh yes, yes,
Okay.
and that's something that should not. I don't think anybody should do that. It's extraordinarily ill-advised, and it gets worse. Sometimes people post that information and invite others to go and do.
There are people who have done that to me as other YouTubers has done that. So yeah. So as far as the law, I mean, what protection would someone who's been doxxed have, you know?
That's the problem. Is not much. Number
Mhm.
one, you have to be in a position to trace who the perpetrator is,
Okay.
which is not always easy. Sometimes it can be done, sometimes it can't.
Mhm.
Depends on how sophisticated the person doing it is.
Mhm.
Also, then you have to. Every state has very specific laws on this. Some
Mhm.
have more specific laws than others. Some don't. In certain situations, it might actually be considered stalking.
Stalking. Stalking. Yeah, I was thinking about that. I was about to say stalking. Yeah.
hmm
Yeah.
So these are all considerations, but this is one of those situations where the law has not really caught up with the technology
Mhm.
to protect people. Think about how long people have been walking around with video cameras on their cell phones,
Mhm.
and just now we're seeing laws come in about things like revenge porn and stuff
Mm.
like that, and exposing people in these sometimes compromising positions. But these are relatively new laws, and those
Mhm.
other laws where people would you know tape a camera to their shoe and look up a lady's skirt or something like that. These are
What
relatively new.
What about if someone posts somebody's body part on their channel or whatever? Is that, I mean, can I place legal charges against the person even if it's not my face?
Yes.
But okay, okay,
Almost every state has laws prohibiting that exact type of thing, and not only
okay.
that, they have
Because
laws
that has
prohibiting
happened to
threatening.
me.
Yeah,
Yeah, because
well,
they
they have
has.
laws threatening that too,
Hmm.
right? And hey Sylvia, you want me to post this on the internet? Well, guess
Mhm.
what? That's a crime in a lot of places, right? How would the
Mhm.
public feel if they saw this part about you? And that's just saying that or typing those words
Well, they
is
have
a
done
crime.
that to me. Yeah.
That then
Uh-huh.
that's definitely crime in most jurisdictions.
Okay.
So there are protections out there, but this is again, it's hard because you're chasing people through the internet,
But if the
and
person is saying it themselves, they say,
uh,
"Okay, this is her breast hair, blah blah blah," that type of thing, then you have a legal, you can take legal action against
you
them,
can
right?
you can,
Okay.
and that's just sort of like an invitation. Come and arrest me and charge me.
Ah, okay, got you.
Yes, and actually, I'll give you a funny story. For instance, I had a client in New York years ago, a
Mhm.
young lady who had this situation going on with an ex-boyfriend and the ex-boyfriend's new girlfriend. It was ongoing. I won't bore you with the details, but the ex-boyfriend ended up posting some pictures of her in a compromising position.
Mhm.
She contacted whoever she contacted on the website, and I had to say this young lady was ingenious. She looked young because she was in her 20s, and she just told them, "Hey, I'm 17. You're showing child pornography," and they ripped those right down in 20 seconds. So, I mean, that wouldn't work with anybody like me. Nobody. If I said I was 17, nobody would buy it. But
But what about posting a child on the internet? I mean, say somebody didn't give up permission to someone to post a child, say the child is underage, and this individual just posts what kind of charges that person could get because them not putting the parent did not give permission for them to post the child on their page.
yeah, you have a. It's not usually going to be a criminal charge. It could be a civil charge of,
Hmm.
appropriating likeness or appropriating someone's images
But giving
without
the
their
address
consent.
too, they gave the address of the person.
Then that might be considered a stalking type offense. It depends. Every jurisdiction, every state is different, but I would I'd go out on a limb here, and I would say that most of the jurisdictions would look very, very, very negatively on somebody posting the picture, especially of an underage person with
Minor.
their
Yeah.
address. Yeah,
So can they sue that person? Can they sue them, even though they're in
they
a different state?
they can be sued. They can be
Hmm.
sued,
Hmm.
and they could be prosecuted as well for pulling a stunt like that.
Okay. 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 Um, because we have, I was trying to wait for other people to ask questions. So, let's see, should we stick with Robert's case or
Whatever
did?
you like. I'm here. I'm on your time, so my talk is free. You can ask me whatever you like.
Okay, guys, do y'all have any questions? I'm gonna put the link in and see if people will come in. Okay, let me just put the link in. Hold on, because I don't want to hold you to up too long, because I don't want to wear out my
That's
welcome because
okay.
we come back.
You won't wear out your welcome. I love coming on.
Oh, thank you, Patrick. Thank you. All right, guys. Um,
I see in the comments somebody talked about Hulk Hogan suing. Yeah, that is correct. Hulk Hogan ended up with a lot of money, bankrupted uh, an entire media company because they posted some very compromising images of his wife, and or not his wife, his friend's wife. He and his friend's wife, and um, that was without his permission. We're talking about violating somebody's right to privacy,
mhm,
which, if you look at the United States Constitution, a large portion of the Bill of Rights deals with the right to privacy.
mhm, mhm.
I mean, that's pretty much the entire Fourth Amendment right there. So these are protections that are very, very, very important to us. We don't want people doing these kinds of things, and you know, with bad intent, basically.
Yeah. Okay. You're gonna have to. Let me see. Let me see. Our friend is back. He's making noise again. You remember, Mr.
Yes.
444? Okay, Dom, did you have a question?
How's it going? Excuse me. How's it
Hi.
going, Attorney Patrick?
Please, please. You don't have to be that formal with me. Simple Patrick is good
Hey, I'm
enough.
gonna give you your respect, man. You went to law school. You're an attorney. I'm
Thank
gonna
you.
give you your respect. But yeah. So I was just curious. I'm gonna just kind of just bounce around. Whenever I have a question, I'll just chime in or whatever. But what was your take on? Because the last time I know you came, I think I missed the majority of the interview. I think it was prior to the conviction, right?
The last time I came on, I believe, is right after the verdict on R. Kelly.
Oh,
Yeah, it
okay,
was
it was
right
right
after the
after.
verdict.
Okay. Okay. So I was just gonna ask, what was your take? Do you think it was excessive, the charges?
Ah,
what do you think?
absolutely, and this is right out of the prosecutorial playbook. Most of them play by this rule, which is throw as much as you can at the person, in the hopes that something is going to stick. Right?
Mhm.
If you give the jury 20 different charges, chances are they're going to end up convicting on at least one. And that's all you need is just one to really wreck somebody's life. And that's, basically that's what they're looking to do. They're looking to wreck you. So, when we throw charge after charge after charge at somebody, we're throwing as many things as we can against the wall to see what's going to stick. And not only that, as you can see, what they're doing with him is, oh, we're going to throw one case after another against you because we're just going to keep stacking this all on top until, the weight just crushes you. And that's what they do.
Mhm.
Thank you. I appreciate that.
I don't. I think it's horrible.
But
And
see,
there's
but the
no
thing
there's
is,
no oversight. There's no oversight.
see, Patrick, the thing is, because I was at the court, I was at the trial, and with the inconsistency, and even when we're going back reading the transcript, I'm like, how in the world did they come up with these verdicts in all 9 counts? I still have a problem with seeing this happening. And then there was no, everything was mostly hearsay. Even the video was not a video that was like, oh, they didn't even let the person come in to explain what the video was about. She got scared, or sick, or whatever, and she never testified. But they let the video into the courtroom.
I've said this so many times in my career, yet I don't think it's never ever been more true than today, which is most cases are won or lost during jury selection.
Hmm.
Because if you pick people that are going to be fair, that are going to apply the law, and have the ability to see things from more than one angle, you at least have a level playing field and a fighting chance. When you don't get 12 jurors that check all of those boxes off, then you're behind the eight ball. And the problem is that the prosecution has the advantage in almost every single criminal prosecution that there is out there. They
Hmm.
get to go first, they get to shape the narrative first,
Hmm.
and the defense is almost always going to play catch up. And that's why I always tell people, when you get that jury summons in the mail,
Hmm.
don't try to get out of doing your civic duty, because but for the grace of God go I.
Hmm.
And everybody in this country gets their chance on the chopping block at one time or another. We have so many laws, so many regulations. It is impossible to go through daily life without violating the law in some way.
Hmm.
All of us get our chance on the chopping block.
Hmm.
So
For
you
some of
just
us,
admitted to breaking the law. I'm kidding. I'm
I
kidding.
always do. Of course, I broke the
Oh,
law.
I tried to tell Bill
I'm
that.
kidding.
Absolutely.
I'm just
I
kidding.
committed. I
We all have, you know. I'm
there's a
just kidding.
book that a lawyer wrote out there called Three Felonies a Day. Actually, I'm in front of my bookshelf. It's probably right up here somewhere. But three felonies a day. The average citizen, without realizing it, commits three felonies a day. Now, me, I try to double up. I'm excessive, so I'll try to commit six a day. I'm kidding. Um, the reality of the
Uh oh.
situation
Uh
is,
oh. That might not be good. Now people might dox you and report you. I'm kidding.
come and get it.
I know.
I welcome the challenge. But
It's all
everybody,
good.
listen, everybody gets their chance on the chopping block. For some of us, it's something as simple as a BS speeding ticket, or a ticket, for some sort of traffic ticket.
Mhm.
For some of us that are less fortunate, it's a hell of a lot more serious. But we all get chopped at one time or another. And the thing is, when the Constitution was made, we took the power out of the hands of the government and put it into the citizens in the form of a jury trial. That's why it's so important that when you get that summons in the mail, that could be you. And one of the questions I ask when I do jury selection sometimes is, If you were the defendant, if you were my client, would you want yourself on this jury? Some people say no.
Hmm.
And a lot of people say, yes, I would. Well, that's good. But get there. Most people would say, you know what, I can be fair, I can be impartial, I can evaluate the evidence, I can, keep an open mind. Well, you know what? Get down to the courthouse and do your part. Otherwise, it's going to be people less qualified than you making life or death decisions for someone else. That's my
Hmm.
public service announcement.
Look, I have someone here who keeps putting out her question. Let's see what Branda's question is. She says, here's her question. She says, what about threats made on the internet?
Yeah, they
Uh,
were Sylvia. They were asking if it was a federal making a threat on the internet. Is that federal or state? Would that which charge would that be?
On the internet.
both.
Was
You,
a
they're,
federal
they're
making a threat on the internet? Is that
Okay,
both.
hold on.
I think we got an echo. That
That's
is both. Yeah,
Hiroshi voice.
there are state laws that prohibit that, and there are federal laws that prohibit using anything in the stream of interstate commerce. Let's,
Mm,
the internet, there's no question that's interstate commerce. Telephone companies, right? Verizon, T-Mobile, they're all interstate companies, right?
mm-hmm,
Anything having to do with the internet is always interstate commerce. If you make a threat over the internet, you could invite the negative attention of the federal government, and you can invite the negative attention of the local state government as well. And you can be prosecuted in both jurisdictions simultaneously, as we've learned time and time again. It all depends on the circumstances, whether the feds want to come after you or not, but definitely ill advised, yes. The short answer is yes.
Why it
now?
seem like the crooks always get away with stuff? There are people who's been threatening people on the internet for years and years and nothing ever happened to them.
It all comes down to the government wanting to pick and choose the losers and the winners.
Mhm.
And it just comes down to, whether you get a group of prosecutors in a particular place that are motivated and want to go after the right people for the right reasons, or if they want to go after the wrong people for the wrong reasons. Um, and that's really what it comes down to. It's just, unfortunately, it's just luck of the draw. There is, and I keep saying this, and I was telling this to a friend of mine in the gym this morning. The problem is that there is zero
Mhm.
accountability for prosecutors in this country. There is something, and most people don't realize this. I was having this conversation this morning.
Mhm.
There is a principle in the law called absolute prosecutorial immunity, which basically means that anything a prosecutor does during the course of his or her duties as a prosecutor can never be the basis of a lawsuit. So they can lie, cheat, and steal in the courtroom,
Mhm.
can wrongfully convict someone,
Mhm.
wrongfully bring charges against someone, and the only thing that you could ever hope to happen to them is that the state bar issues some sort of professional discipline against that prosecutor. That's really it.
Right.
But
Wow.
now we're talking about a state bar that's part of the same government
That they
that is
work for.
employing for the right.
Yeah.
So
Yeah.
you're asking the fox to police the hen house basically.
Mhm.
There is no accountability, none.
Wow.
I agree with you on that too, because I mean, now, do you think how legal is it for an attorney to be speaking to someone who's essentially just a fan or a supporter, and having a personal relationship, as far as saying, hey, like, let's say you were representing, Sylvia, a high profile case, and I'm, a fan or supporter of hers, and me and you, you as the attorney, you gain a personal relationship with me, and we're talking on the regular basis. You say that you're going to fly me out 1 week prior to the trial, and you're going to reveal and give me all of the trial's discovery, the case's discovery. How legal is that?
Well, number one, in high profile cases, normally you'll find some sort of protective order in place that says that, the court says that the lawyers can't disclose certain pieces of information that is exchanged in discovery. So if there's such an order in place, number one, you could be running afoul of the judge's order, which could get you into contempt trouble right there.
Mhm. Mhm.
If if some of that information concerns confidential information, let's say there's a person claiming to be a victim, I have their medical records, I can't be giving that out. That's
Mhm.
protected private information.
Mhm.
If there, so there may be a HIPAA violation or something like that. There's maybe some other provision in the law that specifically addresses that. I could be running afoul of that. I could get myself in maybe sometimes criminal trouble, almost certainly sued. And if I'm disclosing any confidential information or secrets, and that's actually a very broad term that the rules of attorney ethics provides, and secrets and confidential information,
Mhm.
anything about my own client's going to have a gripe against me. So generally speaking, when lawyers want to release information to third parties, it's almost always going to be a situation where they're enlisting the help of that third party for a specific purpose. And even then, you're only going to disclose what should be necessary to achieve that purpose. In other words, if I need you to help me find a witness, I'm going to show you the witness's name, but I'm not going to show you everything else in the case file. I'm going to say, hey, do you know this person here? You know, that's written on this piece of paper. Do you know where they live? I don't need to show you everything else. So that's the only time that a lawyer should do something like that, is if we're talking about a situation where they're enlisting the help of somebody else for a specific purpose, and it always has to go back to, how does this help my client?
Okay. Next, 444 Smile. Go ahead and with your question, sir.
How you doing, Patrick?
Hi, how are you?
How's everything?
Oh, wonderful. How you doing?
I'm all right. I'm great. I got it's a two-part question. One is about the DA, where you said the DA's pleaded immunity.
Yes.
When you look at Jackie Johnson right now, and I don't think she have immunity right now, because I think she's going to open up Pandora's box pretty soon, if you know what I'm talking about.
The prosecutor in Georgia, you mean?
Yeah, because she's been charged in one of these cases. So now, if she get convicted, she may open up the hen house.
She might. That's an extraordinarily unusual situation. I was familiar with that former prosecutor, getting charged with violating the oath. That's something very specific to Georgia. Um, yeah, I honestly, I've never seen anything like that outside of Georgia. I've never heard of anything like that.
And I
Um,
got it's a two-part question, and
sure.
it's dealing with Anna Donnelly, right?
With who?
With Ann Donnelly, the judge on R. Kelly's case.
Okay.
Now, how much pressure you think is on her right now, being that Susan, this new lawyer got on board, and with the media circus around this lawyer, and she's top notch, and she seems to know what she's doing. Do you think that it don't really put pressure on her, but do it get pressure on her to look at it? And do you think that she could, is it possibly looking at it analytically turning it around, or she's preparing a special brief for Anna Donnelly to turn it around so it can go straight to the appeal? What you think?
Well, I can tell you this. There is no pressure on a sitting federal district court judge, and I will tell you why. A federal court judge is nominated by the president, confirmed by Congress, and once they are confirmed by Congress, they are appointed for life. The only way that you can remove a federal judge from the bench is through the impeachment process. With now everybody's aware of that process. And in the history of the United States, I think there's only been two federal judges that have ever been impeached, and I think one out of the two was actually removed from office.
No, I'm not talking about impeachment. I'm not talking about that type of pressure. I'm talking about far as media pressure. She's not going to be receded. I'm talking about, is she under grave pressure to look at this with an open eye, because not because of being removed, because how she could be looked at. She don't care, but she got some people that could be looking at her funny now.
No, a federal judge is the closest thing to a god on earth, because there is no recourse if you make the wrong move. There is no recourse if you want to be cruel and hurt people. There is simply nothing that can be done. So they can do whatever they want because there is absolutely no consequence whatsoever. And it's unlike state court where you actually have to get reappointed or reelected to a position, or in most state courts, you actually can time out. I mean, if you reach a certain age, you age out and you cannot be appointed back to the bench. That is not true for federal judges. They can work well into their 90s, as some of Judge Donnelly's colleagues in New York federal courts have and currently are. So there is no pressure that anyone can bring to bear. No political pressure, nothing.
Now, why is that?
Okay, wait a minute, Dom.
Uh, why? That's a good question. I guess because the Constitution says so, and I'm assuming that nobody ever thought when they drafted these things that we would get so far down to this position where we're at now, where we have basically, and here I'm going on my political soapbox, but we have essentially a ruling class, and then the rest of us little people, right? And the rules don't apply to the ruling class, but they apply to all of us. Um, that's the problem. That one of the major problems that we are facing today is that there is virtually no accountability for people in government. If you want my honest opinion, but we could talk. We could talk hours about that.
Okay, Terry, it's your turn.
Patrick, how you doing?
Good. How are you?
Hey, man. Just sitting here enjoying everything and the knowledge that you bring. So mine is basically almost a piggyback off of Mr. 444's about the judge and Donnelly, two parts. You followed the case, right,
I did.
of R. Kelly,
I did.
and to the verdict. So if you were in Jennifer Bonjean's shoes, or well, first let me ask this. What percentage would you give Jennifer of having this appeal won and the possibility of a retrial?
Tough call. I haven't reviewed the entire transcript of the case, which is extremely voluminous, but I can tell you I know that there are some juicy, weighty constitutional issues that are involved in this case. I can
I like
tell
that word,
you,
juicy.
juicy. There's something you can sink your teeth into. As an appellate lawyer, that I would love that, because in cases like this, people are apt to make mistakes. Judges make mistakes, prosecutors make mistakes, and unfortunately, sometimes defense lawyers make mistakes. When people make mistakes, that gives you a basis to challenge a conviction. And the longer the case goes on, the more complex it is, generally speaking, the more mistakes that are going to be made and the more chances you have. I can tell you statistically, your chances of winning in an appeal in the Second Circuit Court of Appeals, which is the appellate court where the case is going to end up in, is roughly 1 in 10 or 1 in 11, depending on the year and how you want to run the particular statistics. But generally speaking, you have a 10% chance of winning on an appeal. So the odds are not always in your favor because the law says that when there is a conviction, there is a presumption of correctness that the appellate lawyer has to overcome. That is not easy to do. I've done it before. I've done it several times, lots of times actually, but it has never, ever, ever once been easy. Not once.
So it's hard work.
Extraordinarily hard work.
So in this situation, when Judge Donnelly went back over, obviously, the mistakes that, well, I would call them mistakes, that she made and tried to clean it up, is that in favor for her because she is a federal judge? And does the appeal, the judges on the appeal panel look at her I guess, basically admitting to her errors, which in turn will give more favor to her and less to Jennifer of having this case uh,
Yes.
a new trial
Yes,
given.
and it's funny you mentioned this. I was having this conversation with a client just last week. They'd been found guilty after a trial. They wanted to know if it would make sense to have to file a motion to set aside the verdict and a motion for a new trial based on some errors the judge had made. And when I looked over the transcript, very briefly, I said that I think that would be a bad idea, and I'll tell you why. This because the situation you just brought up, when you alert the judge to their errors they were made before the case is closed, they have a chance to go back and make a more complete and full record and say,
Mhm.
this is the reason why I did this. And
Mhm.
now they have the benefit of sitting down, doing legal research, the benefit of hindsight, and to put a square peg into a round hole and say,
Mhm.
well, when I said that, I didn't really mean that. What I really meant to say was this. And
Mhm.
this is the reason why I did this. And this is based on this case and this legal precedence. And really, what ends up happening is it makes it that much harder to climb that hill on appeal, because now you're dealing with a full record with a complete explanation as to why somebody did something, whereas a simple objection overruled or objection sustained, counsel, be quiet, I'm not going to comment on this any further. Well, now you don't have a record, so the appellate court is looking at that and saying, well, we have no idea what's in the judge's mind. Maybe they were wrong, and we know that this is wrong. We don't have an explanation as to why they did this. Now we'll send this back for a new trial. But when you give that judge all of that time to sit down and think it over, go through the instant replay, right, and
Mhm.
really take a look at, whether that guy crossed uh, you know, the end zone with the ball, the tip of the ball, did that touch the end zone line? Did not touch the end zone line? I mean, these are things that you don't want to give, because they almost, these things you don't want to do because they almost always benefit the prosecutor.
Okay.
One
There's a
last one,
there,
Sylvia, one last
okay,
one.
go ahead.
Do you think if R. Kelly had the adequate resources to have more experienced representation, do you think that a lot of the missteps that we have been seeing that happened with the representation that he had, say, in Chicago, I can't uh, blame or won't blame Kenny because he didn't have enough time to prepare for this. So to me, it seems like he laid basically the breadcrumbs for a appeal attorney to come and fight for Robert. But if he had the adequate resources for better representation other than the one he had for the start, do you think that those motions that were not filed or were not challenged or were not presented to the judge would have been more favorable to have a lot of things either admitted or dismissed had he had that representation?
It's difficult to say whether some of those motions would have been granted or not granted, or whether this would have happened or that would have happened. But your question is right on point. And what I do know for a fact is, if he did have more resources, time, money, human resources, personnel, that sort of thing, then his chances would have absolutely been better. And I'll tell you a short story. Years ago here in Orlando, I had a client that was charged with a sex offense against a minor. The girl that was his accuser happened to be a friend of his high school age daughter. And my client was a very well off, um, middle class, upper middle class guy. His daughter went to a private school. He's in the we would consider maybe the upper crust of society. made a lot of money, had a lot of financial resources at his disposal, never been in trouble before. And he had lots of money to spend, not just on lawyers, but on five different experts that I was able to retain, video experts, psychologists, uh, you name it, we did it. Okay. We spared no expense. I spoke to myself to 27 possible witnesses. I had a private investigator helping me. All told, my client spent $225,000 on his defense. And ultimately, it worked because we had amassed so much evidence that proved he was innocent. I was able to bring that into the prosecutor's office, lay it all out, literally lay it out on the table in a PowerPoint presentation, physical, and have my client explain his side of the story. And she said, you know what? I believe your client over this girl now that I've seen all of this.
See,
She dismissed the case. And my client said, you know what? I never thought of things like this before because I've never even gotten a traffic ticket in my life. But now that I faced 45 years in prison, I suddenly realize if I was some poor kid with no money and a public defender, I would bend over, put my head between my legs, and kiss my butt goodbye.
but see, that's the problem with Mr. Kelly's case. Money, for someone to be a superstar like that, not be able to have the finances that to be able to get real good um, forensics and all that kind of stuff. None of that stuff was done. You know.
And that is probably the difference that made the difference.
Exactly.
Not being able to have that money, right?
That's
Not being
right.
able to have access to money
That's
means you
right.
get substandard representation, right? So having
Mhm.
all the money in the world means nothing if you don't have a lawyer with a brain that knows how to use it, right?
Mhm.
Hmm.
Mhm.
And lawyers with brains cost lots of money. So
Mhm.
number one, you have to be able to hire a smart and experienced attorney that's going to
Hmm.
put the work in and is not
Hmm.
lazy and dumb.
Mhm.
Number two, you have to hire all of that, support, right? You're going to need
Hmm.
forensic experts. You're going to need
That's right.
advisors. You're going to need people to do certain, things like develop a profile on the ideal juror for the case.
That's
Mhm.
right.
One of the things that I've come across in the last few years is jury consultants, right? Because like I said, picking the right jury can mean the difference between winning and losing a case. Well, guess what? Jury consultants cost lots and lots of money. Expert witnesses can cause
Hmm.
always cost lots of money.
Yes, they
Private
do.
investigators cost money. When you want to bring in witnesses from other places out of state, well, you got to bring them in. You need somebody to go pick them up from the airport. You need to book a flight. You need to
Hmm.
book a hotel. You need to get them from point A to point B. All this costs time and money. And there's nothing you can't do when you have the money.
That's
But,
right.
think of it. I always tell people, think of it in terms of this, right?
Mhm.
When you're being prosecuted by, let's say, the state of Florida.
Mhm.
Well, Florida has 23 million people, right?
Mhm.
The
Hmm.
state of Florida versus Mr. Defendant. That's 23 million people against one. 23
Hmm.
million people's resources against one.
Hmm. Hmm.
When it's the United States of America, that's 300 million people and the unlimited resources of the federal government against one man. You
Exactly.
cannot bring a knife to a gunfight.
That's right.
Mm.
That's right. And that was my point because they wasn't really able to challenge the prosecution's witness or evidence or their expert, the doctor. I wouldn't say that because I really think that, in my opinion, he had violated the HIPAA law. But if you have that money, you're able to bring on your expert to actually debunk their expert and give a, say, different opinion to the jury when it comes to deliberate.
Absolutely. You have to fight fire with fire
That's
when it
right.
comes to a lot of these experts because, as much as I may know, the expert is exactly that, an expert. They will
Exactly.
always, always know more about ballistics or DNA.
That's right.
or
But
psychology
That's
than I
right.
will. Always.
but sometimes that can come back and bite
That's
you in
right.
the butt
Thank you,
because
Sylvia.
Okay, it's Dom term now. Go ahead, Dom.
Thank you. So, my question to you is, how damaging can it be if someone who is not necessarily charged, but they're being used as someone that is pertaining to your charge? How damaging can that be if if we've spoken? You know, if let's say I'm the one charged, Sylvia's the other one charged, but and they're using us as as far as together as committing a certain crime or a part of a crime. How damaging is it if me and her, or if I've displayed um, that I have been in communication with her on one specific occasion? How damaging can that be to our upcoming, trial or whatnot?
It depends on what the case is. It depends on the facts of the case. But if I'm the prosecutor, I'm using that to show if I'm charging both of you together, for let's say robbing a bank, right? And you still continue to talk with each other, I'm going to argue at the very bare minimum, this is no accident. These people know each other. They work together. They talk on the phone. Look at these phone records. It's Sylvia's number to Dominic's number back to Sylvia, 10 times a day. And, if you don't think for a minute these people are planning something, that these people are in cahoots, you've got to be out of your mind, right? So it takes that whole avenue of defense away from you at a bare minimum number, but it also shows that you are acting together for a common purpose. If they catch you talking to each other.
Okay, the other thing
Wow.
too. What
Okay. And
about?
then the second.
Oh, go ahead. Go ahead, Dom.
Sorry. No. So the second part is now if um okay, so let's say me and Sylvia we're charged, whatever the case may be. We have a upcoming trial, and I'm the main person being charged, but they also charge Sylvia with it, right? With
Hmm.
something along, regarding
Why don't you
this
just give
particular
him the
incident.
R. Kelly incident so he can understand what you're saying? Because
Right. I just don't want to, I don't want to put people's names out there like that. But so let's just
it's
say that, right?
it's
And
on
so
public knowledge. So
okay, okay, for example, with this R. Kelly thing, and he there's another person by the name of, can I say it, Sylvia? I mean, I
yeah,
really don't want
go
to,
ahead.
but
It's public.
If it's
okay,
come out in court, yeah,
now,
you're
It's
fine.
public. It's public.
okay. It's this person named by the name of Don Russell. Okay,
Okay.
and he was a former friend of R. Kelly, or friend of R. Kelly rather. He's known him since he was a kid, and he wasn't around in his camp at all. He was doing his thing throughout 30 years. They've known each other for 30 years, right? And they're charging R. Kelly with running an enterprise. This Don Russell person came about in 2018 when R. Kelly released a certain specific song called "I Admit," which he's speaking on all the life and all these things, and all the negative things that people are saying about him, so on and so forth. So Don Russell thought it was troubling, and he came to his studio, and to have a conversation with him and to be there for his friend. And so they ended up charging. So he allegedly, they're saying that so Surviving R. Kelly, which is a documentary that was released on R. Kelly, that was
He knows all of that.
horrible, damaging.
He knows all
Okay,
of that.
so okay, I don't know. So I'm just bringing him up to
Patrick is
speed.
very well
So
versed of this case.
okay. So now I
So
know.
he ends
So
up getting he
anyway,
ends up
so
getting charged with stalking a witness, um,
right.
in
He ends
order
up getting
to.
charged with
And the
that,
bomb
Right.
threat. And the bomb
Right.
threat.
and the gun threat. So he allegedly called in a gun threat to the Surviving R. Kelly
No,
premiere,
bomb
right?
threat. It was the
So
bomb threat.
okay, bomb threat, gun threat, whatever. It was a threat. So so now he's going on different platforms and whatnot, speaking and telling his relationship, showing pictures, like boom, I know R. Kelly, whatever. But so people were saying he's against R. Kelly. But in this New York trial, he was not a witness. He was not used for the prosecution. So cool, he escaped that trial. But now there's the Chicago trial, and he's when I mentioned the statement about someone speaking to someone, well, allegedly he was on a call with Robert Kelly, and
He recorded the
could that be
call, then he
damaging?
played the call. He played the call while he was
Exactly.
yeah.
While and this was after, I guess, supposedly after R. Kelly's conviction. And
Okay.
so, do you think that could be damaging? Do you think he still could be used against R. Kelly? Do you think he could be against R. Kelly? I mean, what do you think? And just based off what I've told,
The,
what do you
there's
think?
there's a couple of different ways that it can be used against Mr. Kelly. The first way is, if I'm the prosecutor, I want to use that to show what they call consciousness of guilt. Right? I'm in contact with my friend, and if I'm making the argument, what a coincidence that Mr. Kelly's friend just happened to be stalking one of these witnesses that was set to testify against Mr. Kelly, right? Well, you know what? If I was a prosecutor, I'd be imputing that type of behavior that somebody else engaged in onto the defendant sitting over there in the chair and saying he sent his friend out to do this because he knew he was guilty. And that's how pretty much the argument goes. That's one way. Another way that they could do it is they could bring pressure to bear on the friend and say, how would you like spending the next 20 years in federal prison? But if you want to testify against your friend, I'll get that down to 2. And that's what they do. They will use that type of pressure to force someone to testify against someone close to them. So there's a couple different ways that can come back to bite him. And if he just thumbs his nose at the prosecution and says, gives them the middle finger, they'll make him pay a price if that's what
That's
they
what
want
it
to do.
that's what it seems like he's making, because on today's hearing, the prosecutors basically said that it doesn't seem as if he's going to is taking the plea deal that they offered him, because he's been doing appearances on YouTube.
Okay.
So his appearances is basically saying that, that middle finger thing that you're saying.
It could be, it certainly could be a very a very well played ruse. Don't put that past anybody either. But it also goes
What
back
does
to
that mean?
it could be a phony situation where he's going out there presenting like he's giving his middle finger to the prosecutor, but behind closed doors, everybody knows he's really in their pockets. I've seen that happen. Don't discount that for a particular second. Nobody knows what's going on behind closed doors, um, unless you follow the guy 24/7
Mm,
and you
mm.
plant a bug on him and listen to every word he says, which is not really feasible.
Okay. The other question, does it have any effect of the oh, I see a spider. I'm sorry.
It's okay.
But does it have any effect, because I'm gonna get them in a minute. Does that have any effect as far as the sentencing guideline? I got to get this spider. Sorry.
Yes. Unfortunately, you can have an enhancement added under the federal sentencing guidelines for what they call uncharged conduct.
Mhm.
Conduct for which you were not charged, and here's where it even gets even more perverse. Even conduct that the jury acquitted you on. So let's say that there was a mixed verdict, right? The
Mhm.
jury found you not guilty of the gun, but guilty of the drugs.
Mhm.
Well, guess what? And this has happened to me. The judge can say, you know what? I'm going to add 2 points to your federal sentencing guidelines for possession of the gun. You say, wait, judge, the jury said that wasn't proven.
Mhm.
Tough luck, man. That's the law, and that's how it goes. So yes, you can, and it's called obstruction. That's the enhancement, obstruction. And there's a whole section of it in the federal sentencing guidelines. He can receive an enhanced sentence for something somebody else did for which neither one of them have been convicted or maybe even charged.
Wow. So it's best for them to keep their mouth shut then.
I have a
Always.
question.
Yeah, yeah, okay. So you got to keep their mouth shut. Okay. You may answer my question on that one.
I have a question.
Sure.
Go ahead.
You said when you have money, right? But sometimes when you get an expert witness and they highlight, the district attorney highlight how much you paying this expert witness an hour, and they highlight that could be looked at to the jury as 2 ways sometimes, because they see that you putting all this money on the stand and smarts, and they could be able, some jurors see through the money sometimes. So you can, if what if your client would have took the chance and he would have went out there and put those expert witnesses? The prosecutor first question would have said, how much is you getting paid an hour? And when he sit there and say $2,000 to $3,000 or whatever an hour, that can send messages to the jury, correct? So when you think about
Absolutely.
so when you're thinking about throwing money at something, you got to be careful what you throw at, because you don't have to throw a lot of money at innocent.
Well, yes and no. That is a factor for a jury to consider, is whether a witness has an interest or is biased in their testifying, in their testimony, right? And money, of course, is the ultimate bias. Nothing biases people more than money. But this is where the creativity of the lawyer and the quality of the lawyering and the quality of the experts comes into play, because a good expert will testify, I'm not paid for my opinion, I'm paid for my time. And I've certainly had lots of situations in my career where I've hired an expert and they've given me an opinion that was not favorable to me. And they've said, do not call me as a witness because I will end up hurting you. So a good expert will know exactly how to deal with that, and a good lawyer will know how to prepare a witness to deal with that, and to deal with that effectively in front of a jury. But remember, this all cuts both ways, right? Because as a defense lawyer, I get to make that argument too on the prosecution's witnesses, who are almost always going to be already state employees. And the argument goes something like this: you know, Mrs. So and so, you're an analyst at the state crime lab, right? How much do you make a year? You get full benefits with that? You're never going to do anything to endanger that job, would you? And certainly, if you had a negative opinion of the state's case, you wouldn't be testifying here today, would you? Have you ever testified against the state? And the answer almost always going to be no. Um, so that does cut both ways, but a good attorney will know exactly how to deal with that.
Okay, there's a question down here that I was trying to bring to you. It says 10% chance, even if you have gotten your fourth, fifth, sixth, seventh, eighth, ninth, and 14th Amendment right violated
10% chance across the board. Yes,
across
unfortunately.
the board. Okay. Now, as far as, because we're going to go back to that same question with the guy. Now, what is it fair or is it common for the prosecution to sit around and watch YouTube channels for people making YouTube channel comments and all that? It is fine.
Oh,
Okay.
yes.
Okay.
Expect when you go on trial that everything you've ever posted in your life, and we know that the internet has a long memory,
Mm-hmm.
expect that that will be exhibit one at your trial against you,
Mm.
right?
Mm-hmm.
Now, actually, we saw that, was it last week when that kid Rittenhouse testified in Wisconsin.
Mm-hmm.
One of the questions he was asked was, um, is your name on one of the social media platforms, I can't remember which, on Twitter or Instagram, four doors more whores? Yes, the kid said yes. That was his handle on Instagram, I think it was. Right? Everything you've ever posted is going to come under the microscope. And here's what people don't quite understand. um, Nothing you post on any social media platform is private.
Private.
Even
Mm-hmm.
if you delete it, guess what?
They can get
It
to it.
exists. And when you sign up for a social media website and it says the little box, click here if you agree to these terms and conditions, the ones that nobody ever
By
reads.
Reese. Uh-huh.
Well, those terms and conditions specifically say anything you post on our platform becomes our intellectual property, and
Mm.
we have the rights to it, not you.
Mm.
And they have, in all of those social media companies, have entire divisions dedicated to subpoena compliance and law enforcement support. There are people that work at every large media company and social media company and cell phone company. Their entire offices are dedicated to simply replying to subpoenas and giving law enforcement access to this wealth of information. And if you don't think that they're going to use everything at their disposal to mine your social media accounts and look for stuff, you are
Mm,
sorely mistaken. I do it. Anything a witness has ever posted on social media, I will try and find it. And very, very, very often, I will find something that I absolutely can use. Going back to that case in Orlando where my client basically outspent the state of Florida,
mhm,
I found so much stuff on this girl's Snapchat profile,
mhm,
and I had it all printed out in full pages and color prints, and you should have seen the eyes pop out of her skull at her deposition when I showed her all of her posts and asked her to explain in excruciating detail what she meant by each one. A lot of
mhm.
it was extraordinarily embarrassing. But yeah, once it's out there, and
It's
expect it to
out
be
there.
used against you.
Yeah, yeah. Now, as far as me as a blogger, and what I say is basically, I don't know these people that's involved in this case, and what I read is what I'm presenting that. Now, what I say, does that have an effect on the case or what? As a blogger,
Your blog on someone else's case? No,
yeah. Yeah,
no.
thank you.
It's,
Yeah, I
it's
try to
just
tell people that, but they keep saying that what I say. Now, if I knew him, I was part of the case, then there would be a problem. But since I'm just, you
if
know,
you right if you're quoting someone like Robert Kelly, if
mm-hmm,
you're quoting him,
mm-hmm,
that could be used against him. If it's your opinion or your summary or your take
mm-hmm,
on what's going on,
mm-hmm.
no one will give it a second thought in court.
Thank you. I try to tell these people that. Thank you.
No,
I'm a blogger.
that's all it is.
Because
All they'll
they would tell me, "Oh, Sylvie, don't say that," but it's my opinion. It's my what I'm assessing it based on what I think it is. I'm not a lawyer. I'm just giving you my point of view.
That's right. That's
Thank
right.
you.
And as a blogger, she's protected like under the First Amendment, right?
Absolutely, everybody is, and any blog you post is, you're protected under the First Amendment, with some exceptions. Obviously,
Right.
you can't stalk people, you can't dox them, you can't post private
Well,
information about
there's
them,
people who do that to.
you can't
Well,
defame
we're gonna
them,
talk about.
you can't
Yes.
defame them.
Now, someone has called me a pedophile, right? Don't I have and this is a false statement that they're putting out on me. Don't I have rights to file a suit against them? What can I do on that?
That is absolutely defamation, and that's what we call defamation per se, which means whenever you accuse somebody of committing a crime that is false, right? Saying someone's a pedophile means you sexually molest children, right?
Mm-hmm.
Well, that's a crime anywhere you go.
Thank
If
you.
you call somebody that and they are not actually a pedophile, then there's no real legitimate excuse. You can't say, well, my opinion, they're a pedophile. No, 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 no. It doesn't work that way. That's defamation per se. The only real issue in a case like that is, what are your damages? Not
Okay.
whether, in a normal defamation case, you would have to prove that the statement itself is false. But yeah,
But I have recordings of this person saying that, and people send me their YouTube channel saying stuff like that about me, and to me that's damaging because that's my character. You're damaging. Could you mute
right.
yourself 444, please? You do okay. They're damaging my character. Come on, I just muted him and he unmuted himself. They're damaging my character and telling lies, and that hurts. That hurts my
Absolutely.
okay.
It hurts your
Thank you so much.
standing. It hurts your standing, but you don't even have to prove it. The hurt is assumed when
Mhm.
somebody gets accused of something like that, right?
Mhm. Mhm.
Especially with a pedophile, because obviously we know that there's a social stigma attached to people who are convicted of these types of sex offenses,
Mhm.
especially anything involving children. So to say that the damage is pretty much assumed, the question is not really whether you're damaged. The question is, number one, are you really a pedophile? Yes or no? If the answer is no,
No.
then it's just a question of how much you owed.
Okay. All right. Thank you so much, Patrick. I'm gonna be a rich girl in a minute.
Well, as I said,
Yeah, oh, you.
getting a judgment and collecting that
Oh,
judgment,
that's the problem. Being
two
able to
different
collect it.
two
Yeah.
different things entirely, right?
Now, okay. Speaking of that, I just recently won a judgment. and I have not. I mean, can I attach income from all sources when you receive a judgment?
You can. It depends. I mean, every state has their own rules, and generally there's, it's pretty uniform, relatively speaking, across, from state to state. But
Mhm.
there's usually going to be a cap on how much you can attach from the income, just
Mhm.
because, at some point it becomes more economical to not work and not have an income, at least not on the books. So, there's a limit on how much you can attach. But yes, income is one way to enforce a judgment. You can attach that.
Okay. The other thing too, once you get a judgment from a judge, um, can a superior court overturn that?
Which state are we talking about?
Georgia.
I don't know how it works in Georgia, but if you, generally speaking, everywhere, if you get a judgment, um, it can be overturned if there's an appeal or there's a
Mhm.
challenge to the validity of the judgment. There
Mhm.
is a possibility, but again,
Well, let me tell you, the reason I got the judgment is because the person, I sold the car to the person. They damaged the car. The car, I mean, it's black and white.
mhm.
So, can there be an overturn of that judgment if they
But
claim that? Hmm?
If the only way is if they appeal,
but
if there was
Sylvia,
a
don't
trial.
forget to say the part. Yeah.
Go ahead, Dom. Go ahead. Don't forget to say what?
No, I was just saying, don't forget. Okay, so the reason why the person received a default judgment was because he went, they had, Sylvia and the guy had a court hearing. They went to the court hearing. He said, "Oh, my phone is dying." The judge said, "Okay, come back when you get your phone charged." She gave him ample time to come back. He refused to come back. She issued the judgment. Then he went on paper
He.
appealing it, saying that the judge lied. Sorry, he went on,
Okay.
filed paperwork saying the judge lied, and now he's responsible for the whole amount. And now he's saying that the judge lied, he's not paying her, so on and so forth.
Well, it's going to be his burden to show on an appeal that the judge is actually lying about all that. I'm assuming there's a record of the proceeding somewhere.
Yeah, there
So,
should be a transcript. A
well,
transcript.
if there's a transcript, if there's a record of the proceedings,
Mhm.
that will constitute what they call prima facie evidence, which basically means on its face,
Mhm.
this shows exactly what happened,
Mhm.
and it is extremely difficult, if not almost impossible, for a court to say, to look at a transcript and say, hey, you know what? I see what this paper says. I don't believe that's what actually happened. I'm actually going to believe this person over the judge and the plaintiff here, and I will not believe my own eyes. I'll only believe my ears. Um, I'm not saying it can't be done. I'm just saying it's extraordinarily difficult. And if you can pull something like that off, I want to get to know you better.
Yeah. Thank you. Thank you.
I
Mhm.
got a question.
Shoot.
Okay. I'm sorry. Um. Go ahead. Go ahead.
Go ahead,
Four four
Sylvia.
four.
Go ahead.
No, no.
Go
Go
ahead,
four four.
Sylvia.
Go ahead. This
Now,
this person's about to get blocked. I'm blocking them. Okay. Sorry.
okay. Now, explain what's the difference between judgment and judgment by default?
Okay, so and we're talking about civil law. A
Yeah.
judgment by default is I file a complaint against you, the defendant. I'm suing you for XYZ. I'm saying you didn't fix my car like you promised. You owe me $5,000 for not fixing my car like you said. Um, you never answer the complaint. You lose by default, and then whatever I've alleged in the complaint is now judicially established. The court has taken all of that as true because you have not contested it. You have not said, no, that's not true. And basically, now the question is not whether or not you are responsible to owe me this debt. The question is how much. And then the question after that is how am I going to collect? But that's a separate question. Uh, that's one way to default. Another way is, and sometimes this does happen, a judge can issue a default to penalize a party for not complying with the court rules, for not complying with certain orders. It's that doesn't happen all that often, but that does
Wait,
happen once in a while.
when they appeal, when you appeal this and they give the judge some wanky danky story saying I couldn't make it, sometimes the judge look at that winky dinky story and set a new date for a new trial. Right?
Sometimes, yeah, because there's a preference in the law to resolve cases on the true merits rather than on procedural technicality. Like a default is what most people would say that's a technicality. It is. There's a preference in the law to resolve cases on the real merits of the case. Um, Sometimes a default can be overcome. Sometimes they can't. I've been on both ends of that, so
Me too,
yeah,
myself.
yep.
Awesome. Anybody have any questions? And let me click the links. Click the link if you'd like to come, because I'm about to let
Hey,
Patrick go in the next 15 minutes.
can I just get
Well,
Oh,
one last
sure. Go ahead.
question
Go
in
ahead.
really quick? Now just back to the R. Kelly case. Do you think it's odd that that they're saying that R. Kelly obviously he was charged with the running an enterprise himself. Do you think it's
Right.
odd that none of his immediate circle, no one that's been around him for all 30 years, have been charged but him, and then they're charging people who came around, someone like a Don Russell who came around in 2018, and then the two other people who randomly got charged, and R. Kelly doesn't even know them. Do you think that that's odd? What would you think about that?
It is odd. And when I deal with the federal government, one of the things in the back of my mind is, do they have some sort of secret agreement with some of his inner circle to either stay out of the way and not get involved with the defense, or B, actively work against them in order to avoid charges themselves. And sometimes you can see and I've seen situations where after the dust settles with Mr. Kelly, you'll see an indictment being filed against some of these other people because the prosecutor has not charged them strategically until Mr. Kelly's cases are done, because they didn't want to compromise those people as potential witnesses against him, and they wanted to keep some leverage over them to prevent them from becoming potential defense witnesses. I've seen that happen. And that is absolutely a possibility, because whenever you have a situation where someone's a cooperator, right? They're charged also. They agreed to, testify for the government in exchange for more lenient sentence against one of their, friends, or, you know, co-defendants, or, co-conspirators, or whatever the case may be. That always gives the defense a line of argument that this person's not being truthful with you, ladies and gentlemen of the jury, because he's just working down a debt that he pays to the United States government, and he's going to say whatever he needs to say to get himself out of trouble, because he doesn't want to sit in a jail cell. And who's deciding his sentence? Not you, not this judge, but this prosecutor right here, the same person that happens to be prosecuting my client. You have that argument, and when that person is not charged, that takes that whole argument away. So, that may be a situation. That's one possibility. Another possibility is they just didn't have the evidence to go against some of these other people. They just didn't have the witnesses. They just didn't have the forensics. They didn't have the cell phone messages. They didn't have the cell phone records. They didn't have any of that stuff. That's one possibility. But see, the whole thing is, you never really know until so far down the line when all the dust settles.
Okay, here's a question down here. It says,
Thank
"Are
you.
there any consequences? Are there any consequences for media spreading false narrative? Can we, the public, sue?"
No. There is decision after decision after decision that basically says that when you turn on CNN, when you turn on Fox News, when you turn on, all those NBC, ABC, CBS, you're not really watching the news. You're watching what's considered under the law to be entertainment. And they can spin anything any which way they want, because the courts have always said nobody really takes them seriously. Well, we know that's not exactly the case, but um, when you're talking about false narratives, then we're also talking about potential defamation. And you will see, media walking usually a very fine line between saying that someone, let's just use a pedophile, right?
Mhm.
If you say, well, so and so is a pedophile, well, that could be defamation unless they really are a pedophile. If they were convicted of, a child sex offense, then truth is a defense to defamation, then they are by definition a pedophile.
Mhm.
If you say he's charged with being a pedophile, that's not a false statement. Now, you can imply as much as you want that the person is guilty, but as long as you say he's only charged at this point, not that he actually is, that's how you escape liability if you're a media company. But yeah, generally
But
speaking, with the false narratives, I mean, just there's no recourse for us as the public.
so it's just basically as long as can they say allegedly? Like, a lot of people's like
Yes.
allegedly.
Yes.
Okay.
Yes. Allegedly did this. Allegedly did that. We know he allegedly did this.
Oh,
You're
yeah.
qualifying that statement with that word allegedly, or he's
Mhm.
being accused of.
Okay.
But that's how they get out of it.
Go ahead, Terry. Terry has a question for you, and then I guess one more question, then we can let you go.
Thank you.
Yeah, I think you just answered it because what I was going to say, of course, this person isn't a big media company, right? They're just a blogger.
Mhm.
Okay. And I've actually heard your answer for Sylvia's case. But
Mhm.
let's just say there's a blogger and let's just use me as an example. Let's just say there's a vlogger and she has labeled.
Okay.
Mm,
Right.
Number
And
one,
nobody
you're
can
going to
hear
look
you because
stupid.
you're buffering. We're buffering, so
Uh,
I'm watching you
No,
on
we
my
can hear you.
TV.
Okay, you guys stop talking, sir. Go ahead. He was
I can hear
it's
you.
talking.
okay.
Yeah.
Number one, you are going to look stupid as all hell saying that. Number two, no good can come out of the situation because the courtroom is a public room, and
mhm,
everybody who's in that audience has an absolute right to be there unless
mhm,
they act out and disrupt the proceedings. But if they're
mhm,
sitting there quietly following the rules, it doesn't matter who's there. And second, who are you trying to score points with? Right? If you,
mhm,
if you try to if you're trying to score points with a jury, the time to make that argument or the time to mention something about that is not to the judge when the jury is outside of the courtroom. The time to make that argument is during the summation. All you're going to do is aggravate the judge, aggravate everybody in that courtroom, and you're doing your client a disservice. At
Mhm.
the end of the day, you're doing your client a disservice because you know what? Those kinds of things aggravate judges to no end. And while they may take it out on the lawyer, it almost always is going to come back and boomerang on your client. So keep your mouth shut. Don't make things harder for yourself. It was just dumb.
Yeah.
Right. That's what I thought too. I was like, wow.
Well,
So,
thank you again, Patrick. I'll see you next time after the verdict. We'll talk.
All
Thank you
right, I'll be
again.
here.
Have a
thank you so
wonderful,
much,
wonderful
attorney.
evening. Okay, bye-bye.
All right, good night, everybody.
Good night.
Take care, attorney Patrick.
Guys, that was great. Just in time. You know what? They've been causing mine and chokes thing. They've been reporting our live. They hate the truth, guys. Everyone was
Right.
complaining that we were buffering. My live and Choke's live has been
that's
buffering.
sad. That
Mm.
is sad. But you
Wow.
At
keep pushing.
least we
That's
got
all.
some answers,
Yes, you
Randa.
did.
Uh,
Yeah.
Yeah.
uh, we got some answers. Oh, so we got those recordings of him saying I was a what?
Mhm.
And not only that, he
It's
said,
going down.
and Sylvia, you heard what he said. He said, now, if he could pull that off, that he said a judge is lying, he said, I want to get to know you more because that's not gonna happen. You're gonna owe that money.
Mhm.
So that was good. But yeah, in all seriousness though, that was a great interview.
It was
It
great.
wasn't too long, but it was great. He got to the point and answered very good questions. You
I
know.
just love having him. He's really good, y'all. He does not mind
Mhm.
us. That's why we have to have those questions for him. And
Right.
it was really good. It was really good because I really wanted him to come and answer some of the questions I had for personal reason. You know what I'm saying? you know,
Right,
you
Yeah.
right,
know,
yeah. You
and
have to
that
get it in.
Avalon, Randa, that Avalon comes in and harass me all the time, even on my comment page. So I was aware of that person. I think it's one of Bozo's people. She comes in here and do that to me
Mm.
all the time. I let it slide a couple of
What did
times,
they,
but today was not the day.
what
Well,
did they
she
say?
damn
She
sure
says,
gonna have
if
something
you
to take back
ask,
to
she says, if you
Bozo.
ask, says, if you ask a question, you could Google the question that you ask.
Hmm.
But that's why the whole point of having an attorney on is to ask him the
So I don't
questions.
have to
I mean,
Google.
you don't have to Google, yeah. And not only that, if he's taking his hard-earned time out the day to come do that, clearly he feels that Sylvia's page and Sylvia's a good person enough to do that. Because you're not going to come to
Yeah,
someone's page who you're not, you don't think that, you want to be on. So what's the issue? You know,
yeah.
we had
And
questions
plus,
and he
Google,
answered
you
them.
got to read it. She just like hearing them saying it like we
Oh
do.
yeah, because I love, I mean, it's so great to have favor. God gives you favor with attorneys that, these people,
Right,
Right.
to get a consultation, how much it costs to get him to sit down and just ask him questions, just come into his office. That costs money.
Right.
right, right.
And
Exactly.
chat, I know
So
you had a
we appreciate
reality
his
check.
time.
I know you had a reality check. So you know how we have to really be careful of what, well, not so much the chat, but the other vloggers, because if our brother only has a 10% chance of having his appeal uh, overturned where he gets a new trial, that's not a big chance. That's 90% chance the opposite way.
And then here's the deal, that money part came in again. That is one of the reasons why he was found guilty, because he didn't have
Right.
the finances to get the
No,
experts
he
that he
didn't.
needed.
That's why I asked
Right.
that question.
Yep.
That
That's
was a
why
very
I
good
asked that
Exactly.
question,
question.
Terry. That was a very good
Because if
question.
because if you have the money,
Exactly.
you're able to challenge the prosecution's witness
Absolutely.
and everything. You're able to start at the beginning with the motions and stuff, and then even in that, Rob deserves to have a chance to.
Okay, y'all, we gotta go. Choke is
Okay,
live. Let's go.
okay,
We're going
all right
over
then.
there. See you later. Where's my
Have a good one.
party? Where's my party part? Where's my Randa? Put it up. Randa, put it up. I don't have it. Randa, put it up.
Your party. What you mean? Party
Man,
what?
Randa, you digging me? Y'all know what I'm talking about. Trees. Put it up.
Oh, okay. Okay.
Put it up. Put it up.
Y'all be easy.
Look at the private. Oh, he just left. Randa, put it up. Okay, guys. See you later. Great job, everybody. Thank you.